Ever feel like you're navigating a maze blindfolded? That's kind of what renting property in another country can feel like sometimes, right?
Oh, absolutely. One wrong turn, maybe you miss one small step in the process, and suddenly, you could find yourself in some unexpected trouble.
Yeah. Well, today we're doing a deep dive into a real-world situation that one of you shared. It's a really difficult rental dispute involving a Japanese tenant right here in Taiwan.
Hmm. And looking at the materials you sent over, it's clear this person is in a pretty tough spot. A big part of it seems to be not following the standard procedures for property handover when they moved out.
Okay, right, the handover. So let's unpack this. We've got a couple of YouTube videos and some Taiwanese court documents. The main issue seems to be this tenant, a Japanese man, let's call him Sato, and his Taiwanese wife.
Hmm.
They're being chased, basically, by their former landlord with all sorts of legal claims after moving out. And crucially, they did what's sometimes called a single-party handover.
Meaning they moved out, documented the condition themselves, filmed it, and then sent the keys back by registered mail, but without doing that joint inspection with the landlord.
Exactly.
And that's where things get really interesting, legally speaking, and, well, unfortunately, where it seems things went wrong for them here in Taiwan.
So our goal today is really to understand what happened, what went wrong.
Yeah, and explain the correct way to handle a property handover in Taiwan, because it's specific. We also need to talk about the sometimes, let's say, uneven playing field between landlords and tenants here.
And the legal bits that are relevant.
Right.
Okay, so let's start with Sato's story. It's laid out in this YouTube video. The title translates roughly to Absent Move-Out Inspection Leads to Accusation of House Occupation. Taiwanese-Japanese couple expose they Taiwan landlord's bad acts.
Quite a title.
It is. In the video, Sato and his wife share their experience, and they actually mention having had good rental experiences in Taiwan before this one.
Which makes this current situation even more, well, shocking and upsetting for them, I imagine. It highlights a real contrast.
It does. Their earlier experiences sounded pretty smooth, cooperative, but then they rented this larger place for their leather workshop. It was a 5-year contract.
Okay, long term.
Yeah, and they admit, openly, the contract wasn't, super favorable to them initially, but they said they trusted the landlord's goodwill.
Hmm. And that reliance on goodwill, especially when you're maybe less familiar with the local system, it can be risky if you don't fully grasp the formal procedures.
Totally. So during the tenancy, problems started cropping up: leaks, old fixtures, even a toilet that broke.
Oh, wow.
But when they brought these up, the landlord's response was apparently always renting as is,
Yeah.
refused to fix anything.
Right. Renting as is. That's a really key phrase. It's a legitimate concept, where you agree to take the property in its current state, but it really should be crystal clear what that covers. It sounds like Sato and his wife felt it was being maybe misused to dodge repairs that came up later in their 5-year term.
Yeah, and it gets worse. The landlord apparently brought in someone, called him a repairman, who just dismissed their concerns. And they even allegedly threatened them for posting about the issues online.
That sounds incredibly confrontational, not what you expect.
Not at all.
Yeah.
So, then comes June 2024, they decide to move out. They followed what they thought were the right steps,
Okay.
told the landlord, filmed the property condition meticulously, put the keys with a formal termination notice in a registered letter.
Okay, documented everything.
But the landlord just didn't show up for the handover appointment.
And this is the critical point. Under Taiwanese law, as we'll see from the court cases, just leaving, even sending the keys back, doesn't automatically count as a legal handover if the landlord isn't involved or doesn't acknowledge it.
So you can't just assume.
You really can't. It's a key takeaway. Don't assume your past experiences apply. You have to know the specific legal procedures for things like move out in the place you're renting now.
Right, so the couple just assumed, okay, the landlord will probably just keep our deposit. That'll be the end of it.
A common assumption, maybe.
But no. Instead, bam, multiple lawsuits. First, the landlord claimed NT $220,000, that's new Taiwan dollars, for unpaid rent, damaged utilities.
Okay.
But then that amount jumped to NT $510,000 in the later suit, and then, get this, NT $780,000.
Whoa, that's a huge escalation.
Now, on top of that, the landlord sued Seto, the husband, separately as well.
The escalating claims and the separate lawsuit. It does suggest a potentially, let's say, aggressive strategy from the landlord side. You can see why the couple would feel targeted.
Definitely. They actually reported the landlord to the police. They suspected it matched a pattern they found online called "원예유," which is basically like second landlord fraud tactics, situations where someone sublets improperly or uses dodgy practices.
Interesting, they found parallels online.
Yeah, and they pointed out contradictions in the landlord's own lawsuits. Like, how can you claim both breach of contract and demand ongoing rent for the same period? It doesn't really add up.
It's a very good point. Those claims seem inherently contradictory. If the contract is breached and terminated, demanding ongoing rent for future months doesn't logically follow. It raises red flags.
And the landlord apparently even boasted about knowing the local court system really well.
Oof. That alleged comment about knowing the system is worrying. It could imply an intent to use procedural familiarity as leverage against someone perhaps less familiar, like a foreign tenant.
The couple insists they tried to document everything: call recordings, the registered letters, photos, videos. They really tried.
And that documentation is important, absolutely.
But they still feel incredibly stressed, like the system is stacked against them. It's really tough to hear about.
It is. And it highlights that documentation alone isn't always the whole picture. You also need to ensure you're following the legally mandated procedures for that jurisdiction.
There's a second YouTube video where Sato's wife explains more. She talks about why they signed that initial less-than-great contract.
Ah, okay. What does she say?
Basically, it boiled down to trust. And feeling grateful, that the landlord agreed to rent to them for their business.
That makes sense. It really speaks to a vulnerability, doesn't it? Renting in a foreign place, maybe language barriers, you might feel pressure to accept terms just to get settled. That initial gratitude can sometimes, unfortunately, overshadow the need for strict due diligence.
She also mentioned the landlord flat out refused an early termination, even though they had put money into renovating the place.
Wow, even after renovations. That's gotta sting. It really underscores why having clear, agreed-upon exit clauses, even for early termination, is so important right from the beginning in the contract.
Yeah, she keeps coming back to the renting as is thing and the landlord's broken promises and those contradictions in the lawsuits.
Mm-hmm.
And she gives some really solid advice. Check public judicial records for a landlord's name before you sign anything.
That is excellent advice, seriously practical. Checking public records could potentially reveal a history of disputes and save renters a world of pain. Definitely worth considering.
She also described this weird situation during a police investigation where the landlord's wife suddenly claimed she wasn't actually the landlord, even though she seemed involved.
That sounds like an attempt to muddy the waters, perhaps.
Maybe. And her final point is pretty sobering. Even with a standard contract, it might not be enough to protect you if the other party is determined to act in bad faith.
That's the hard truth, isn't it? A contract relies on both parties acting honestly. When one side decides not to, even a solid contract can lead to long, expensive legal fights.
Okay, so that's the really distressing picture from their side. Let's pivot now to the legal angle. Why is this handover process so critical? We have a court document here. The file name ends in .negatinghandovervalidity.pdf. It's not their specific case, but it deals with a handover dispute. What can we learn from it?
Right. This document is really instructive. It gives us insight into how Taiwanese courts look at returning a rented property. The legal term is fes.
Okay.
The core idea, supported by a specific Supreme Court judgment mentioned in the doc, is that returning the property means giving possession back to the landlord, as per the agreement. It's not just about physically leaving.
So more formal than just dropping the keys.
Much more. The court explicitly says that the lease ending in this case, it was March 22nd, doesn't automatically mean the property has been legally returned or handed over. There's a separate step.
That's a crucial distinction. Lease ends, but the handover responsibility continues.
Exactly. This court document actually debated whether the handover happened on March 4th or way later, in November. The court decided it was November.
Why so much later?
Well, things like the landlord trying to get into the property and a related, though dismissed, trespassing complaint against the landlord actually indicated that legally the tenant still had possession. Even the tenant saying they left keys inside without telling the landlord, not considered a valid handover by the court.
So leaving keys isn't enough. Got it.
Yeah.
There needs to be that formal transfer the law sees.
Precisely. And this brings us to the specific law, the Rental Housing Market Development and Management Act. Article 12, Section 1 defines handover.
Okay, what's the definition?
It's defined as the process where the renter returns the property and any equipment, and here's the key part, both parties jointly confirm the quantity and condition.
Ah, the joint confirmation. That's what seems missing in Sato's situation. They did it solo.
Exactly. A Proper, legally sound handover under this act requires that mutual agreement and confirmation of the condition together. Once that's done properly, the renter is generally off the hook for responsibility, unless they cause damage, obviously, and the landlord gets the property back free and clear.
Okay, but what if one side just doesn't cooperate? Like the landlord in the YouTube story who is a no-show.
The act actually anticipates that. If one party fails to cooperate with the handover, the other party can formally set a reasonable deadline for them to show up and cooperate.
Okay, so there's a mechanism.
Yes. If they still don't cooperate by that deadline, then it can be legally considered a completed handover. But the crucial step is formally setting that deadline and documenting it. You can't just assume non-cooperation equals completion.
Right. So back to Sato and his wife. They sent the keys by registered mail after telling the landlord they were leaving, but no joint inspection happened, and it doesn't sound like they formally set that deadline for the landlord to cooperate.
Correct.
So their unilateral action, even with good intentions and documentation like photos, probably wasn't seen as a legally complete handover under Taiwanese law.
That seems very likely to be the crux of their current legal vulnerability. They tried to do the right thing by documenting, but they missed the required procedural steps for the handover itself.
And this really shows how landlords, who maybe know the system better, can potentially use these procedural points to their advantage.
It certainly highlights the importance of knowing the rules. We have another court document here. Tenant pays 200 KNTD from the new Taipei District Court. In this case, a tenant tried to break a lease early due to noise.
Okay.
But they ended up being liable for unpaid rent and penalties because the lease specifically prevented early termination for the reasons they gave. The noise wasn't considered a condition meeting the contract's requirements for termination.
Ouch. So the contract terms are really powerful. Read the fine print.
Absolutely critical, especially clauses about early termination. However, it's worth noting, in that case, the court did reduce the penalty the landlord demanded. It found the original amount too high.
Oh, that's interesting. So courts can sometimes step in if a contract term seems excessive?
Yes, they have the power to review penalty clauses for reasonableness, even if they were agreed upon initially. But the core obligation, like paying rent until the lease properly ends or is terminated according to its terms, generally stands.
Connecting this back to Sato. They admitted their contract wasn't great, and the landlord wouldn't let them leave early despite the renovations. It really feels like once you sign, you're kind of locked in unless you follow the exact exit procedures.
That's often how it plays out. There can definitely be a power imbalance. Both the YouTuber's story and the second court case show how tenants can face significant financial risks if they don't adhere strictly to both the lease and the relevant laws, like the handover rules.
And for foreign renters, maybe less familiar with the nuances.
It's doubly important. Be aware of these dynamics. Be meticulous about following formal procedures like that joint handover.
Yeah, you can really sense the frustration from Sato and his wife. They clearly feel the landlord acted unfairly, not showing up and hitting them with all these lawsuits. It must feel awful thinking the legal system itself is being weaponized against you.
That sense of unfairness is completely understandable. While the law aims to provide a clear framework, how it gets used and interpreted in practice can sometimes feel lopsided, especially if one party seems better equipped to navigate it.
So let's try to boil this down. What are the absolute key takeaways for our listeners, especially anyone renting, maybe in Taiwan, maybe elsewhere unfamiliar?
Number one, absolutely understand the legal definition and the correct procedure for property handover, or SUK, in Taiwan. That joint confirmation of the property's condition by both parties is usually essential. Don't assume just leaving or sending keys is enough.
Right. Sato's attempt, doing it alone, however well documented, likely wasn't legally sufficient in Taiwan, and that seems to be the root to their problems now.
Exactly. Second, be acutely aware of the potential power dynamics and challenges in the local rental market. Read your lease agreement cover to cover, especially clauses on early termination, repairs, and that renting as is concept.
And document everything.
Document all communication, keep records, and seriously consider Sato's wife's advice. Check public judicial records for a landlord's litigation history before you sign. It's a proactive step.
It's such a stark contrast to their earlier positive rental experiences here. It reminds us that while things can go smoothly, you just can't afford to be complacent. Due diligence and following the rules are non-negotiable, especially if you're a foreigner navigating a new legal system.
Couldn't agree more. And you know, this whole situation really prompts a final thought for you, the listener. When you are renting in an unfamiliar legal environment, possibly dealing with assertive landlords, What concrete steps can you take before you even sign and during the tenancy to really protect yourself?
Beyond just reading the contract.
Yeah, beyond the contract, what resources are out there? What strategies can you employ? Are there tenant support networks? How can you actively ensure your rights are protected to avoid falling into these kinds of incredibly stressful disputes? It's something really worth thinking about proactively.